It's good to see you all today. I have a good topic to talk about. I have been telling you about VAWA. Now, if you're joining me for the first time, I'm going to talk about what it is and then jump into what do you need to show to get VAWA. Now, VAWA is the name of the law is Violence Against Women's Act. Here's what you should know. It is not just for women. It is for all genders, and it is for all forms of marriages or relationships. So it is for say for examples for same-sex marriages. It's for the man and woman type marriage. It is for parents, step parents, adopted parents, in regard to the parent-child relationship. And so when you think about the Violence Against Women's Act, you should not be thinking this is just for a marriage or a spousal situation, but it also is for those who are experiencing mistreatment by a U.S. citizen or legal permanent parent, or by a U.S. citizen adult son or daughter who's age 21 and up. So, say that citizen son or daughter, maybe they started to mistreat you at 17, but now they're 21. It's at this point that you could also apply for relief. And the kind of relief you get is to get a special status called, it's the VAWA status, which means you get placed in deferred action, protection from deportation, but it doesn't stop there. By getting the VAWA status, it means that you can also apply for permanent residence. In the case of, right now, for example, as the spouse of a U.S. citizen or legal permanent resident right now, as the child under 21 of a U.S. citizen or legal permanent resident, and as the parent of a citizen, you're able to, at the same time you're applying for the same status, you can apply for adjustment of status. That means to get permanent residence while staying in the United States. The other thing about this is that it allows you to stay here even if you've crossed the border without permission. So that does include relief for those of you who have crossed the border without permission or overstayed. So, in many other situations, if you have crossed the border without permission, you will not be able to adjust status unless you can show that you received parole. But in this instance, with VAWA, you are able to apply for the VAWA deferred action status and then get permanent residence. The other good thing is that you're able to get your work permit and your social security and your travel document at the same time that you're applying for this form of relief. So, as you can see, it offers many benefits. If you are in the situation, which I know many individuals are, you are able to pursue this. And it is confidential, by the way. You can apply for this even if you're still with the spouse, the parent, or you're living with the adult child who is mistreating you. We make sure, though, one thing I do want to say is if you are residing with them, you have to make sure that you're safe. And we also work to make sure that our clients are safe as we're going through the preparations to file and also as we're filing. And one of the safeguards is that we serve as the main contact person for the USCIS. So if they have any correspondence, if they're scheduling a background check, if they're scheduling an interview, we're the first ones to get it. And then after that, we pass it on to you safely. So that is the way that you're able to, do this in a confidential way and not put yourself in harm's way, especially if this person has been threatening to you or has been physically violent with you in the past. Now, as I mentioned, physical violence, I also want to let you know that violence and abuse and mistreatment comes in different forms. So it is not just based on abuse by physical violence, but also emotional. So if you're being mistreated emotionally, if you're being mistreated verbally, that does count, even if those are the only things that this person is doing to you. And also extreme cruelty. So if you have one of these people in your lives, and they are extremely cruel to you, or they're vindictive, they're jealous, they deprive you of certain things, they put you down, they are jealous, they are controlling, they don't allow you to work, or they make you work too much. These are examples of ways in which this is abuse, but ways in which their actions also subject you to extreme cruelty. So it's a broad definition. VAWA allows you to apply based on a broad definition of mistreatment and abuse and extreme cruelty. So now let's talk about what is required for to get this approval for VAWA. And I think that's one of the things that stops a lot of people from even looking into whether they qualify. Is like they said, yeah, my spouse, my parent, or my even my adult child, citizen adult child, they did mistreat me, but I can't prove it. That should not be your starting point, by the way. Your starting point should be, did this happen to you? If it happened to you, then it is worth pursuing it. So, and the reason why you're allowed to just say, did this happen to you? And if it did, yes, you pursue this, is because any credible evidence counts. That means that you don't have to present proof similar to, say, what's required in a criminal hearing, where it's like proof beyond a doubt, or you have to show what you do have to show is evidence that makes what you went through credible to the officer. If it is believable to the officer and the officer accepts it as truth, then that means that you have a shot at getting this. You have more than a shot at getting this approval for the VAWA. Now, good, go back. Let's go back to no proof, right? Now, you're wrong in that if you say you don't have proof, you're wrong. And this is why you're wrong, because you have your memory. The very fact that you can remember the kinds of things that were done to you, the kinds of vindictive behavior of your relative, the actions against you, the abuse, the mistreatment, the yelling, the name calling, the jealous acts. The fact that you can remember this means that you can present the evidence, because one very, very central piece of evidence would be your very statement, your statement. Of course, it has to be drafted correctly and consistently to be to be accepted as evidence by the officer. But as long as it is done correctly, then the officer will accept it as evidence and then can base their decision, in some cases, based only on the declaration. So that's a very, very important document. And when VAWA applications have been denied, it's because individuals, even though you have your memory and you put this to paper, you may not necessarily understand how to approach it, what's relevant to put in there. Your memory may be foggy. You may, as a result of that, you may just put pen to paper and not necessarily present it. And then if the officer has any questions about inconsistencies, that means that you're at risk for a denial, right? So you have to be very careful about how this is presented, because inconsistencies, you have one shot at this, right? Because when you're submitting that statement, which is we call it a declaration, you are saying it's like a testimony, right? The same kind of testimony you're doing in court. The only thing is you're signing to it on paper. And so that means that you can't, you won't have a second chance to go back now and change it if the officer writes in a request for evidence to clarify certain facts or to point out certain inconsistencies. There's no, let me do this all over again, right? It's similar to testifying in court, where now when you're trying to do it all over again, they're questioning your credibility. They're questioning whether your statements are ever even true. And at the point that the officer is questioning that, that means that you are likely to get a denial and you won't have a second chance at it. So that's the number one thing that where I see people get denials, because they think that it's just a matter of writing down something or typing out something. They don't put it in the proper format. They don't include the relevant evidence, and they are not careful about presenting the information in a way that the officer can understand. So the officer may interpret some things as inconsistencies when it may not be, but and then you have further complications in your matter. So you have to, even though it is your statement, right? You still have to be very careful about this. And I do sit down with my clients for hours, making sure that everything in there is accurate, that everything in there is consistent and orderly so that the officer can understand. And then what do you put in there, right? Because this declaration is not just talking about what happened to you. I mean, that is the central part of this declaration. But you also, it's now evidence. So you also have to present it in a way that with relevant information to show you qualify. Because if it's your only piece of evidence, it means that you're going to have to make sure to include all the requirements, that the fact that your marriage is bona fide, the fact that you resided with your relative, which is a requirement, the fact that you have good moral character. Those are also relevant pieces of information that the officer needs to see in the declaration. And if you skip through those, then it means a request for evidence. And of course, when it comes down to good moral character, because you do have to show good moral character, it depends on what the situation is. It depends on the applicant's background. But a background check, a separate background check, for example, we conduct a separate background check for our clients that we include to show that our clients are individuals of good moral character, or to make a case as to why they have good moral character. For example, if you yourself, you were arrested because this relative, maybe they attacked you, maybe they lied on you, maybe they called the police on you, that's going to be very relevant to talk about in the declaration as well, because then the officer can look at that to determine whether if this conviction or arrest is going to affect your immigration, they can forgive it based on the fact that whatever happened to you happened because of the mistreatment. So, that's an example why it's so important to make sure that you are represented to help you with the declaration, help with your statement, because you don't want to gamble with your statement. You want to make sure that you have legal representation to help you with that. I mean, there are other aspects of this application that you do have to include, and if you do have other evidence, you by all means that should be included as well. But the main thing is, when you're applying for VAWA, you do have to show that your marriage is bona fide, is bona fide, or that you have a qualifying relationship, such as a parent-child relationship. Um, and you also know it changes just depending on where you are and what kind of relationship you had, but proof that you resided with your spouse is going to be important. Proof of your good faith marriage is important. And then also evidence that if, for example, in the parent child relationship, it's going to depend, right? Because if your parent shared custody with you or you visited them for purposes of VAWA and the parent-child relationship, that still does count. So visitation, for example, can count as residing with the parent. So you don't have to necessarily live with them 24/7. That's why, just depending on the relationship, evidence is also going to be different. But I mentioned proving good faith marriage, right? Because that can also be challenging in these types of cases where normally when there's for example, when there is an imbalance in the power dynamic between the parent and the child, or the spouse and the spouses. Usually that means that they may not share accounts together. Some do, some don't. But where one is very controlling, they may not have access to the home, they may not have their name on the lease, they may not have access to money, they may not have access to the car, they may not have access to benefits. And that is where I, as the attorney, I have to then focus on how the abuse affected the client's ability to show this traditional type of evidence that they have a bona fide marriage, right? So it's also going to be different on the way we approach it. Is going to be different. And this is where the declaration is important, because that's going to be very relevant in the declaration, right? It's not that not only, oh, they did this to me, they did that to me, but it's also going to be what why is it that you could not prove the bona fides of your marriage, that you entered the marriage in good faith. So just depending on what the context is, we that's how we approach the declaration as well as the evidence that we're going to provide. All right. So that in a nutshell is what I wanted to talk to you about, and it's what do you need to prove forward to prove what do you need to get approval for VAWA, right? And you should make sure that you understand the importance of the declaration, that there is certain information that should be included in there, that if you miss it, it can lead to devastating consequences in your VAWA case. And even it can even lead to more complications, more questions, and the officer ultimately denying your case. So that declaration is central. And there are other types of evidence, but with those other types of evidence, it's going to really depend on what actually happened in the relationship. Now, put your questions in the comments, because I'm here to answer your questions as well. So I'm going to go ahead, and I see one on YouTube, so I'm going to answer that one. So you have submitted your VAWA declaration and you have received a receipt as regards to it. What's next? So after you filed your VAWA petition, you usually get a receipt notice. So that's saying we've received it, we've accepted your case, and now it's in process. And then after that is the biometrics notice. So the biometrics notice is where they're going to do the fingerprinting to do their own background check. If you've applied for adjustment of status and a work permit at the same time, then that usually comes after the background check. The biometrics is about 2 months. I'm seeing anywhere from 2 weeks to 2 months after we've applied for this type of application. And then then after that, the biometrics is the work permit, which is coming anywhere from 6 months to 12 months after applying. Now is a good time to apply, because keep in mind, fees are going up. At the earliest, we could see fees go up in March. It is a proposed regulation now to increase the fees, the filing fees, and filing fees are going up for the adjustment of status application, which we file along with VAWA. So you want to make sure that if you are looking into getting or applying for this, that you get on it right now because it can take a while to prepare to file this case. You can go ahead, you can contact me, schedule a consultation. We can talk about your particular case and get started. All right. So let me just scroll through, make sure I'm not missing anybody's questions. I'm going from the top. All right. I thought I saw. Okay, so if you do get approved, will they be sending your green card? So the first thing that's going to happen with approval of VAWA is that they will send you deferred action and a work permit, another work permit. The deferred action goes for 2 years and is renewable. But while you have this special status that basically protects you from deportation or any kind of immigration enforcement, they will automatically, as long as you've already applied for adjustment of status, you either upon approval have to apply for adjustment of status at that point. But if you've already applied for adjustment of status at the same time that you're applying for VAWA, then they will automatically schedule the interview where all being well, you're approved, you would then get your permanent residence. So it is a process. You do get your work permit and social security number while you're applying for all of this, but the entire process takes about 2.5 years to actually get to permanent residence. Is the I-130 the only form needed to file for parents outside of the US? So it's going to depend. I cannot say that the I-130 is the only form needed. Just because I don't know what the situation is. More forms may be required just depending on what's going on in the case. At minimum, though, the I-130 is the starting point to apply for parents who are outside of the, even in the US, that I-130 would be filed. However, if you're talking about outside of the US, at minimum, you're going to start with the I-130. So I want to talk to you in private. What should I do? Absolutely. That's where I speak with you in a consultation. So you can go ahead, schedule the consultation. This is consultation for legal advice, where I can advise you about what's going on in your immigration issue, determine whether you qualify for benefits or relief, and then go ahead and get started should you want to move forward. And we do move very quickly to get started on our client's case right away. It's worth it to go ahead and schedule this because you're getting legal advice and you're getting a legal evaluation, and that alone puts you at an advantage to understand your situation, to understand options that you may not even have thought about, and then to move forward. Is it possible to submit an application at a center within the states that has a faster processing time than the state you reside in? No. So you should send it to the service. And actually, the USCIS did send out a tweet. I remember some months ago about this. They're like, please do not send to a service center just because you think it's going to move faster, and do not refile your application thinking it's going to move faster. You're actually doing harm because that's going to delay your process. That's going to go ahead and cause complications in your process. So you don't want to do that. Follow the instructions. There are specific service centers based on, and so, say one state may accept applications for those who live in a number of states. So you need to pay attention to where you need to send it and not where you believe you should be sending it because it's faster. Is there a fee for the consultation? Yes. So my fee is $150 for up to an hour. And in that consultation, that's where I do a detailed evaluation, determine whether you qualify, and then provide you with the quote to move forward should you qualify for representation. But at the same time, it's worth the investment because what you're getting the information you need to understand your process and understand how you're going to either find a solution or how you're going to move forward to achieve your goals. So it's worth your time and money for that consultation. All right. So I don't see any more questions. So I am going to call it a day. It's been a pleasure to see you today, and I hope this information was useful. I will be back tomorrow at around the same time to provide you information and then to get started. Um, Okay, so I now in regards to it's going to depend on what this type of business visa you're talking about and whether you qualify. If you're referring to the E2 treaty investor visa, I absolutely represent clients and help them to get the E2 treaty investor visa. That is where you have to come from certain countries. So we'd have to check and then also we have to evaluate your business and whether you're in the position to apply for that. That's where the consultation is going to be very important. So, the way that I know whether you qualify for my representation is in the consultation. Now, let me tell you how to schedule that consultation, and it's very simple. Right now, you're on Instagram. As soon as I come off the live, you can go to the profile, go to my profile. You see the link. Click on the link and it will take you to a page, a link tree, where you'll have everything you need to get in touch. You will see the link to schedule your own consultation. You'll see the link to go to the website where you can then use the contact information on the website. Contact information is the phone number, the contact form, the online chat. All three leads to the scheduling coordinators who are more than happy to help you to schedule. But as I said before, you can even schedule your own appointment and confirm your own appointment and get on my schedule. So that's how you're going to get in touch with me to talk about, talk about your particular situation. It doesn't have to be what I talked about today, but if you're in an immigration, if you want an immigration benefit or you want an immigration relief, you want permanent residence in the United States, then I am the person to talk to. And what you'll also want to know is that I represent clients in all 50 states and around the globe. So no matter where you are, I can represent you. For those of you who live outside of, I'm based in Boca Raton, Florida, but for those of you who live outside of Florida or not close to me, then we do phone and video consultations and we can continue to work together after that. All right. Okay, thanks everyone. Have a great day. I'll see you tomorrow. Bye bye.